CJ Corona, the Chief Justice, should not have included that amount in his salary because they didn't own that amount, that money. I'm asking a question.
Well, to us, it should be included in the salary.
But you said they didn't own that money.
No, we did not say that.
Misappropriated. When you say you misappropriate some amount, you don't own it.
What we said, Your Honor, was that she treated it as her own, and therefore should have been included
but
in the salary.
they didn't own that amount, that money.
They have to prove that, Your Honor, because that is
Anyway,
the burden is
I'm
on the
just
defense
curious
with
because,
respect to that.
you know, that's your statement struck me.
I'm sorry, Your Honor. I was about to reply.
Yes, you may reply.
To the
yes, sir.
statement that the burden of proof is in our. They are in all criminal prosecution or even in civil cases, Your Honor, the burden of proof is always on the party who alleges. They were the ones alleging, Your Honor, that this is property of BG Basa Gidote, Your Honor, and it was received by Mrs. Corona only in trust. Not even Mrs. Corona can be held liable for not including her if she has a separate statement of assets and liabilities.
That is correct, sir. And since, as stipulated in the corporate certificate, corporate secretary certificate, she was only entitled to 5% commission.
Yes.
So is it also your contention that Mrs. Corona or the Chief Justice should only include the amount equivalent to 5% of 34.7 million?
If she received the amount and she was paid, Your Honor, and in fact there is no evidence to that effect, I think if she receives, she may be liable.
Anyway,
but not Chief Justice Corona. She has nothing to do with the transaction, Your Honor. She is neither the buyer, much less the seller, nor is she an agent or the broker. In other words, we have here a case of general accusation. All right, perang pumunta sa inyo yan, i-account ninyo. We do not agree with that kind of proposition because anybody else can be held. I'm not referring it to the...
All of this discussion will be cleared up when the defense shall have finished its presentation of evidence. I do not know whether they'll present Mrs. Corona, what other witnesses they'll have to present, but if they'll present Mrs. Corona, she'll be the best person to explain all of this.
Yes, Your Honor. We fully agree.
So,
Mr. President,
yes,
Senator Ralph Recto wishes to be recognized.
the gentleman from Batangas.
Thank you, Mr. President. Mr. President, I am glad that on this last day for March, as far as the impeachment trial is concerned, we are now going to the other important matter in the SAL-N. We are now on the personal and other properties, which has a relation to cash, cash in bank, and liabilities.
This is the heart of the problem.
Precisely the point, Mr. President. Mr. President, the whole day today, or at least after, during the testimony of Mayor Atienza, it has been pointed out by the defense as their witness that Mrs. Corona, in trust for Basa Gidote, received 34.7 million in cash. Isn't that correct? That's basically what the defense is saying.
That's the amount of the check, Your Honor, which was paid to her in her capacity.
Correct.
As representative.
And based on the documents, this has been deposited in Land Bank. I think, if I'm not mistaken, Land Bank in Manila.
That's not clear, Your Honor. There was an allegation to that effect, but that is no evidence, Your Honor.
But isn't it correct as well that in previous testimonies, as of December 31, 2010, the cash in bank should have been in account number 089-121-021-681, 7,148,238.83 cents. Account number 089-121-019-593, 12,580,316.56 cents. That is in the PS Bank, the 2 peso accounts. And then you have a BPI account with 12,024,600 67 pesos and 70 cents. If I look at the SAL-N of the Chief Justice as of December 31, 2010, cash and investment, various years, 3.5 million. Okay? There was also testimony and evidence that on December 12, 2010, a withdrawal was made of roughly 34 million. Or 2011. Isn't that correct? Yes.
That appears to be the evidence of the prosecution, Your Honor.
Correct.
If you are asking our side, Your Honor,
Yes.
just kindly wait. We are not yet through with our opportunity.
No, I understand. This is in relation to this 34 million Basagidoti.
Yes, our point is...
That's all I'm trying to point out.
I'm sorry.
Yes. Okay. Now, there was a withdrawal in December 12, 2011. May I ask the prosecutor, isn't that correct?
That's correct, Your Honor.
And if I recall the testimony then, that this withdrawal was tinanggal yung pera dahil wala nang tiwala sa PS Bank, and this money is the money of Basagidoti.
That is not the evidence for the prosecution.
Okay.
That was I think, in the media, in the newspaper.
Okay. Is that the evidence of the defense?
Are you...
That withdrawal, that 34 million withdrawal.
Yes.
Is
what?
that, I may not have my notes now, no, but there was a withdrawal as testified here by the PS Bank manager, if I'm not mistaken. 34 million ang withdraw noong December 12, 2011. And that is why hindi kailangan makasama naman yon dun sa SAL-N ni Chief Justice noong 2010.
Hindi po yun ang aming bersyon, ang aming depensa. Ang aming depensa is this money which allegedly were deposited, whether in the dollar account or peso account, are merely held in trust by Chief Justice Corona, Your Honor.
Correct.
Coming from the proceeds of the Basagidoti account and also the money sent to them by their children, Your Honor.
Okay. Pero basta maliwanag, itong 34, sa Basagidoti ito. And I'm following up the point of Senator Ping Lacson here.
If that question is directed to me,
yeah, it could be directed to both, yes, to the Defense Counsel.
Well, we have not yet started presenting evidence in that regard. So how can there be an evaluation, an appraisal, and conclusion? I hope you clearly. Yeah. I hope as a judge in this case, Your Honor, I would plead most respectfully that kindly receive the evidence with an open mind, because if your mind are already closed, these are the money of Justice Corona, and they were not registered. Therefore, he has violated the provisions of SAL-N, Your Honor.
No,
in fact, even the allegations of paragraph 2. Article 2, Your Honor, under paragraph 2 and 2.3, there is nothing mentioned about the failure to state this and so on, or the irregularity.
Yes.
What
I
appears
just
is non-declaration.
want to assure the defense that I am not making a conclusion. I'm just trying to understand the evidence presented here, whether testimony or documentary, and what is being presented by both the prosecution and the defense. Because right now, that's the way I see it, and this is the more important, I think, issue now, is that we're almost done with the real properties. And we're already now talking, this has relevance to cash in bank, liabilities as reflected in the SAL-Ns. And I promise the defense that I will listen to every piece of evidence that you will present in this court.
Thank you, Your Honor.
And seek some clarification if necessary, similar with the prosecution.
With respect to that, to the statement from Senator Rector regarding the PS Bank accounts, I think on the part of the prosecution, it's very clear, Your Honor, that based on our offer of evidence, all those bank accounts in the year-end balances in the name of Renato Corona, we presented it as evidence. It should belong to us. It belongs to the Chief Justice.
Maybe you can
so
correct me.
that is the position.
I could be right or I could be wrong. But, I'm giving you the opportunity to correct my impression. Okay? last question. I go back to the 34.7 million. It may not be the same amount, but my recollection is, that you can correct me if I'm wrong, December 12, there was a withdrawal.
That's correct.
Of roughly the same amount. Okay,
Roughly,
the same amount. Okay, as testified here by the branch manager.
But that
Yes,
34,700,000
Yes, something to that
should
effect.
be netted by 11 million that was reflected in the SAL-N of the Chief Justice as liability advance from Basa Guidote.
There were numerous occasions in the past, Mr. President, that there were liabilities of 11 going down to 5 until it was fully paid, apparently in 2009, if I recall. My data is in my desk.
2010.
I don't have it right in
In
front of me.
2010,
Or in
it was
2010.
fully paid.
It was fully paid.
As it
And
appears in the
therefore,
SAL-N.
It does not appear in 2010.
That's correct.
It appears in 2009, the last account.
That's correct, Your
Right?
Honor.
So parang nabayaran din niya. And that's why, in December 12, kompleto pa rin yung halaga. In trust for nga naman eh.
Oh.
That's all I'm trying to drive at. Now,
Yeah, but our position, Your Honor, just to make it very, very clear, all those bank accounts submitted as evidence belong to the Chief Justice because it was in his bank account, including the 3 bank accounts withdrawn and later on deposited in the same bank on December 11, 2012.
I understand the position of the prosecution. Whether it makes sense or not, I will not make a judgment at this point in time. But from the defense, would you care to comment on that observation?
Well, Your Honor, please.
Or at least from my recollection,
From the manner you make a narration of facts, I hope you pardon me for saying that you have considered only the evidence of the prosecution thus far. I hope I'm wrong.
Yeah.
Because you have never cited any evidence on the by the defense, Your Honor. And we are just starting. Why did we bring about this question of sale of the properties of
So what is the purpose? That there was 34.7 million cash given to Cristina Corona. I understand that is the purpose.
No, that it was received by Mrs. Corona in trust.
In trust for, precisely.
So is it hers? Even if we follow your logic, Your Honor, is it
I'm not
hers?
saying it is hers.
Oh, precisely. So why will he be
Precisely.
Why will the husband be accountable for that?
I'm not even saying that.
Well, that is the inference. That is,
No.
you made me understood that way because
No,
my
I just
objection
said-
is this. You are making a summation of facts, but solely on the basis in favor of one party. Why? Because there is no evidence yet on the part. We have never discussed about these deposits, Your Honor.
Do
So
not
the
worry, I
only
will listen to your defense.
the only concept that you have is the concept coming from the prosecution's evidence, Your Honor.
Let's,
I will no longer belabor the point, Mr. President,
Let's
and
wait
I
for
assure
the
the defense that I
Yes,
will
we have-
listen
Let's
patiently.
Very unfair.
let us keep cool. We have plenty of time to assess this, and we are going on a recess. We have 1 month
Precisely.
to ponder about the whole
Yes.
case. And when we finish hearing the defense,
And precisely,
presenting
Mr.
their
President,
evidence,
we are just asking
we
for
will wait for the
clarification.
rebuttal of the prosecution. At that point, we will know the whole picture.
Yes, Your Honor, if clarification is sought,
We will wait
why will the
patiently.
clarification come from the defense when it is not our evidence, Your Honor? Is that not unfair?
We understand. I understand.
Thank you,
The
Mr. President. I will
clarification
no
must
longer
come from
belabor
the
point.
prosecution, not from the defense. That's not our evidence, Your Honor. In fact, we are just starting. We have not yet presented the Chief Justice if he will testify, the wife, Your Honor. That's my point. All the summation made by the Honorable Chairman Rector, Your Honor, appears to be on the basis solely of the evidence for the prosecution. And to us, it appears, and I hope the court will